On behalf of the class of 2009, it is my pleasure to welcome Judge Michael Mukasey.
Thank you, Mallory Silverman, for that kind introduction. Thank you, Dean Boger. Thank you, Sarah Coughlin, President of the Class of 2009, and Matt Rodell, President of the Student Bar Association, and Liz Tillotson, for inviting me to deliver this year's commencement address. And to you, my fellow law students in the Class of 2009, my warm congratulations on what you've already achieved and on what you will achieve in the years ahead. And speaking of that achievement, the faculty members who have helped you thus far, and whose wisdom will continue to help you in the years ahead, deserve pride of place at the beginning of this talk, and congratulations in their own right. I should also not let the moment pass, as others have not, without pointing out that today is Mother's Day, which is as fitting a symbol as you could probably find, for the simple truth that none of us got here under our own steam. And this offers an opportunity to pause and to thank not only the mothers in the audience, but all the other members of our family and friends who provided the nurture and support that made this graduation day possible. I applaud them as well, and I invite you to join me. As a former Attorney General, but even more as a former judge, it's a special privilege to be invited to speak here at a law school that has trained so many members of both the state and federal judiciary, which speaks volumes about the quality and concern for public service that are as characteristic of this university as Carolina blue, which, by the way, never looked as beautiful as it did against Michigan State. This university and this law school have a history of inviting speakers who reflect diverse views on important legal and public policy issues, even when those views and people are occasionally, as they are today, subjects of controversy. That history is consistent with what elevates American legal education, and in particular, the education provided right here, above mere indoctrination, and makes it worthy of being regarded not simply as career training, but as education, and indeed, higher education. Commencement speakers traditionally are expected to offer bits of wisdom and guidance to the graduates. But I think that the usual wisdom and guidance are something one should not presume to offer others generally, and particularly not to law school graduates, as you are. Your skills and training not only equip you, but in a sense obligate you to find your own way of being true to yourselves and to your profession. All one can ask is that lawyers, as we are, recognize that since law is a profession, it has to profess something. And that one important thing that it professes is that lawyers are obligated to learn enough about the hardest subjects and questions so as to confront them as honestly and as intelligently as they can when they must provide an answer or advice. The way I plan to put a little bit of flesh on that rather bare-bones observation is by referring to the subject that, oddly, I found most surprising and challenging about being Attorney General, which involves the nature and the scope of the terrorist threat that we confront. As a federal district judge, I had presided over several terrorism-related matters, and so I thought that I really knew something about the subject before I went to Washington. But as Attorney General, every morning, I received a classified briefing on the various threats our nation and others faced up to my last day in office. Those briefings were simultaneously sobering and alarming. The enemies we faced, and still face, have a presence literally in every part of the globe, and yet in many places are virtually undetected. And the plots that were the subject of those briefings were both creative and deadly. Now I say this not because I'm thinking before, but because I think I'm standing before people who do not know that this is a serious threat, but rather to underscore that because this is not a conventional struggle against a conventional enemy with an identifiable location on a particular and identified battlefield, The main weapon we have in this war is intelligence. As may become apparent later in these remarks, gathering information for intelligence purposes is a lot different from gathering information for purposes of presenting evidence at a trial. And in that difference lies a great deal of the controversy we are witnessing and participating in today. The topic is of particular relevance, and I hope interest, to you as graduating lawyers, presenting, as it does, the most significant challenge to our legal system in our times. It is no surprise that questions about how to confront that challenge have generated vigorous debates, presenting, as they do, questions that are among the most difficult a democratic government can face. How we as a nation should seek to protect ourselves, whether the steps we take are proportional to the threat and consistent with our history and principles, where the legal lines are drawn in this new kind of conflict, and as a matter of policy, how close to those legal lines we should go, and whether the lines themselves can be or should be redrawn. Over the last 3 years, we have studied legal and policy issues, in part by considering cases that present those issues, whether hypotheticals or real cases. At the risk of intruding on the day that is supposed to represent the end of law school, I would like to consider with you one last time a case that illustrates several legal issues we now face. It's the case of a man named Jose Padilla, who, as it happens, is an alumnus of my courtroom, among others. After the 9/11 attacks, which killed 3,000 people, most of them within sight of the building where my courtroom was located, Osama bin Laden and his al-Qaeda network set about planning new waves of attacks. Jose Padilla was supposed to be one of the participants in those planned attacks. Mr. Padilla, as it happens, was an American citizen and a convicted felon who, after he served his jail sentence, journeyed abroad, where he acquired several aliases and a new career. He enrolled in al-Qaeda training. Now, I could spend a good deal of time on his itinerary, the details of the training he received, and what you BlackBerry users might describe as the contact list that he acquired on the way. But I will simply summarize, not only for the sake of time, but also because, frankly, some of the details of his exploits and those of his cohorts are not in the spirit of the day, and in any event, are not crucial to the discussion.